Hey, my name is Joe Tunstall, and I've been practicing personal injury here in North Carolina for about 23, 24 years. And we get calls every week that our attorneys are answering about why my child, who is under the age of 18, has been involved in an injury either through a car wreck or a slip and fall or a medical negligence. Why do we have to have a court hearing to approve that settlement? I'm going to go through some of these questions we get on a regular basis. The first one is, why is a court hearing required? Well, if the insurance company or the defendant or the plaintiff, which is the minor, request it, then you can have a court approval. And in that case, the judge will come in and look and make sure the minor's protected. There's no exploitation by the parents or by the attorney or by, quite frankly, anybody else. Make sure that the amount is fair, that it's adequate. If there's a limited amount of insurance, that it's the correct amount that's coming in, and that it compensates the child for their injuries that they've gone through. In North Carolina, with certain limited exceptions, minors or people under the age of 18 cannot make these decisions for themselves. So the second question we get is, do I have to go to the hearing? And the answer is yes, you need to go to the hearing unless the attorney tells you not to. And the reason for that is often the judge wants to hear from the parent. They want to hear from the child. If there's, let's say, a scar or the child has a broken leg, he's going to literally ask the child, whether that child be 8 or 13, do you have any trouble running, moving? How does this affect you? Where will it happen? Typically, we're going to file this in the courthouse closest to the minor. So if the child lives, let's say, in Raleigh or Charlotte, we'd have it there. If they live in one of the outside counties like Wilson, we'd file it there, wherever they happen to live. When will it happen? So after the settlement, there's a lot of documents that got to be put together by both sides. As soon as those documents are together, then we will set that hearing. What about this guardian ad litem that suddenly pops up? So you hear, hey, we're going to appoint Attorney Smith as the guardian ad litem in this case. And you say, well, what is this guardian ad litem? Well, the court likes an unbiased representative to come in and make sure that the child's financial interests are looked after. So a lot of times in North Carolina, and specifically in certain counties it's required, it's an attorney that has no financial interest whatsoever in the case. It looks at everything and tells the judge it's the right thing to do for this matter. Or may look at it and say, it's not the right thing to do for this matter. They're an independent attorney who can make their own decision. So the court's going to talk to the guardian ad litem, the parent, the child, the attorney, and try their best to determine if it's the right thing for this particular child. Again, my name is Joe Tunstall, attorney here at O'Malley Tunstall in Eastern North Carolina if you have any questions.